So I want to talk briefly about the remedy of reinstatement that's available under the County Labor Code. And basically, the law on this subject is that the arbitrator or adjudicator, the person hearing the case at first level, has discretion to fashion the appropriate remedy. And it's in that person's discretion as to whether reinstatement should be the appropriate remedy. Generally speaking, the factors include whether the individual has shown the intent to show a viable working relationship. If there were some performance issues, but not enough to terminate for cause, has the individual recognized these things and shown a rehabilitative intent? Basically, from both points of view, is the relationship workable? Can this relationship work out in the future? So the arbitrator, again, or the adjudicator, has considerable power, and once that power is exercised, then it's not likely to be overturned on review. The reviews, by the way, go to federal court, but let's leave that out of the picture. This raises a second issue, and that is, well, what happens if reinstatement is not ordered? Can there be a damage claim for future lost income having not succeeded in the reinstatement argument? And the answer is yes. And to this subject, there's two different approaches. One approach is to say, well, we're going to fashion the remedy based on what that person would have earned in some type of reasonable future period. If the person's 60, as I mentioned in the previous video, that person might get lost compensation until age 65. It may be discounted by the possibility of finding other employment or some other risk factor that would reduce the claim. That's the basic first approach, is to assess how long should we award compensation for into the future, and how should we discount it if a discount is to be applied. The second approach is akin to a wrongful dismissal claim, and that is to say, all right, we're going to give compensation for the loss of the job, and that compensation often is formulaic. It's a month or a month and a half compensation for every year of service, and then adjusted upwards to reflect the loss of the security of the position, given that person would no longer be employed under the federal law and have to seek employment elsewhere. So that's basically approach. In each instance, the arbitrator has considerable discretion how to fashion the remedy, and again, completely unlike anything in wrongful dismissal claims. As I mentioned before, there will also be a ticking time clock for lost income until the date of the hearing. So if the hearing takes a year and a half or 2 years, or the case is appealed and is not resolved until the appeal is finalized, that clock continues to tick for lost income, just like under human rights claims. So it's a big remedy, and you should be aware of it if you're employed under federal jurisdiction and you meet the definition of eligibility to file a complaint. Again, keep in mind, there's a 90-day time period to file a complaint, so be smart and be wise.